So Jack, it's not every day that we get to sit across somebody of the stature of our guest today. So I'm really excited. I know you're excited. And for those of us watching, or those folks watching and listening in, we have the distinct pleasure and honor of having former Justice of the Texas Supreme Court, Justice Medina. Welcome to the podcast.
Well, thank you for having me, and I'm honored to be here in your presence.
Well, we appreciate you making time for us. And Justice Medina, when we were first talking about having you come on the podcast, we looked over your bio, and it was fascinating, your rise from your humble beginnings to all the way to the top of the profession, I would say, right, Jack?
Absolutely.
And your story is one of inspiration, one of perseverance. And I don't want to take away your thunder, but I do want to let our audience know how, you started off just like any other person. And so we want to hear about that. So tell us early on, how you became, worked your way up all the way to become a Justice of the Texas Supreme Court.
Well, sometimes I don't believe the good Lord's allowed me to have this journey because it's been incredible, and I've been blessed every step of the way. It's just amazing. I was born in Galveston, Texas, right down the road. Grew up in a small town called Hitchcock, whose basketball team just won back-to-back state champions, so congratulations to those Bulldogs.
Awesome.
But back then, it was a little town with two flashing lights, and we grew up, and my three sisters and I, and my parents, they raised us in a small community, and we had a little small farm with chickens and a couple of goats and some sheep and a cow and pigs, and we grew our own food back when we were organic before it was cool to be organic. So we always had food to eat, and had clean clothes to wear. My parents worked real hard to make sure they provided everything that we needed.
Yeah, and if I'm not mistaken, you went to law school while you were working, right?
Yes.
So what was that like?
It's just, for me, it wasn't difficult because I really enjoyed going to law school. I felt certainly a blessing to be able to go and be able to not only help my family immediately after I finished, but help others. And so it was fun. And it's just really budgeting your time. That's what we all do. We have so many hours in a day, and we just budget our time. So instead of watching high school football on Friday nights and college football on Saturday afternoons and pro football after church, I studied, and that was it, just rearranging time commitments.
Yeah, and how old were you at this point when you decided to go to law school?
I was about 27.
You were 27. So you started a little bit later than most folks do. Right. And where were you working at the time? What were you doing?
About halfway through law school, when I started law school, I was working for a company called Travelers Insurance Company.
Yeah.
But right at the halfway point, I went to work for a company called Cooper Industries. And so I was working there. Both jobs were full-time jobs, real jobs. I had to be there every day. And then I would scramble to get to law school to start class at about 5:35 or so. And when I went to work for Cooper, it was a little easier because it was essentially right across the street. So I would find a good parking spot and just get over to class and stay there from 5:30 to the last class and go home and have some family time, get up, do it again. We finished.
Yeah. And so you finish law school and you start your legal profession at that point. I'm assuming Cooper's was not a legal firm.
Well, it's at the time was a Fortune 100 firm.
Uh-huh.
A big company, had offices all over the world. And I was in a risk management department.
Okay.
With the opportunity to join the law department if I continued to work hard and I did well in law school. Well, that opportunity happened for me, and I was hired to go into the law department. Became at the time the first lawyer hired directly out of law school. So most lawyers there had about a minimum of 5 years of experience in firms. So I was an in-house lawyer, and that's how I started. I had a great opportunity by Mr. Alan Riedel, who was our general counsel at the time. He moved me to the law department, and I worked for the late, great Dwayne Emmerich, who was the associate general counsel of the law department.
Okay. And so you were in-house counsel at that point.
Right.
And then how did you go from there to public service?
It's a fascinating story. You never know who you're going to meet along your way of your career and through your life. But I became friends with a man named Al Gonzalez, who became really a mentor to me, although we're pretty much the same age. But we were involved in community service, talking to students and encouraging them to stay in school and things that we should be doing. And through that friendship, Al eventually became the then Governor Bush's Secretary of State, and eventually became General Counsel to Governor Perry. And that relationship opened the doors for me to become a state district judge. It's really at the time not something that I thought I would pursue or that opportunity would even actually come in front of me, but it did. And so I had the blessing to go do that. And that's how I got into public service. I was elected and then was reelected. Then about halfway through that second election, second cycle, I got called from Cooper. I got a call from Cooper Industries. My general counsel at the time, Ms. Schumacher, asked if I was interested in going back to Cooper. And it's something that I always aspired to do. I wanted to be the general counsel at Cooper at some point, and that presented the opportunity to do that. So I left public service and thought I would contribute in other ways, but go back to the private sector.
Well, that's awesome. I mean, talk about it organically. You started with the company, ascended, came back to them, and kind of realized your dreams, some of the goals that you had. That's fascinating. How would you say your experience in this journey has shaped the way you look at the justice system?
It's, the justice system are things that we experience either personally, or we know others and certainly family members that have experienced one way or another through all the courts. And, law school opened my eyes into how the justice system works, but actually being a lawyer and getting down there certainly gives you a better perspective. With Cooper, I got to travel all over the United States. Participated in trials, I think in about 46 different states, and some small counties, some big counties. And then it also took me to Canada. We had litigation in Canada, so I got to see how that system works. Had litigation down in Mexico. I was down there often for environmental issues. And proud to say Cooper had a great environmental program. Our facilities were extremely clean. We operated those facilities just like we did the facilities in the United States. And then it also took me to Europe, where he had litigation over there. So I got to see how other systems work. And by far, I believe our system here in the United States is the best. It's not perfect, but it's certainly better than other systems. And it's through that those travels, that eventually led the opportunity for me to be considered for Governor Perry's general counsel. I was actually in British Columbia working on a case when I got a call from Governor Perry's office asking if I was interested in being his general counsel, which, it's like the governor of Texas. It's a pretty big deal. Right. And so that opportunity unexpectedly just presented itself. And as I said earlier, it's hard to believe that these opportunities have come my way. And then I really had a difficult time leaving Cooper, because for me that was my dream job. Start at the very entry level and then rise to the top. But also working for Governor Perry was something fairly significant, knowing that my friend Al Gonzalez had worked for Governor Bush at the time as his general counsel. It's something I aspired to do, and so Governor Perry was kind enough to bring me in his fold, and I was able to do that for about 10 months, and then there was an opportunity to be on the Texas Supreme Court, which it's just being in the right place at the right time sometimes really, really helps, and being prepared for when those opportunities present themselves. People have asked, well, you've been lucky, but what is the definition of luck? It's being prepared when the opportunity presents itself. And so all of the experiences I had with Cooper certainly prepared me for these opportunities. And when I got to the Texas Supreme Court, it's just unbelievable. When I was in law school, I had the privilege of meeting then Justice Raul Gonzalez, who was the first Latino elected statewide. And so that left an impression on me. And he and I had a really brief conversation about public service, but I really didn't think those type of things would come my way. And so when it did, I flashed back to that time. So, wow, here it is. I'm going to be on the Texas Supreme Court, and it's sometimes still hard to believe that I got the opportunity to do that.
That's awesome. And I want to talk about that because I think that's fascinating, Jack. I mean, we hear about the Supreme Court, whether it's Texas Supreme Court or federal Supreme Court in the news, but it's almost like so secretive. So I'm really excited to kind of pick your brain a little bit here. Maybe you could shed some light on some questions that we have. So you get there, and I believe you've authored over 90 opinions.
Is about, I think, 95, somewhere around there.
Right. And vast array of topics, obviously. Right. Tell us, what is that process like when a case reaches the Texas Supreme Court, says, okay, we're going to opine on this case? What does that look like? What's the process look like there?
Well, the appellate process is you start at the district court level, and the party that loses has an opportunity to appeal to the courts of appeals in that jurisdiction. So here in Houston, we have the 1st and 14th, and those appeals are automatic. So you get an automatic right to appeal. The losing party there has an opportunity to appeal to the Texas Supreme Court. Now, the Texas Supreme Court, those appeals are not automatic. The court decides which cases it takes based on the significance of the case and whether or not it's significant to, as we say, the jurisprudence of Texas, the laws of Texas. Or if there's a conflict in the law, let's say that the 1st and 14th Court of Appeals in Houston say the law is A, an appellate court out in West Texas say, no, the law is B. So the Texas Supreme Court will try to resolve that conflict. So those are the cases that it took. And it's you go through all of these petitions, and you have to decide amongst all the 9 justices which ones are the most significant. So when I first got there, this is interesting. We should talk about this one. We should write about this. And you come to the realization we can't do them all. So you really have to be selective. So that's the process. And then once that's decided, you have sit around a conference table and talk about each case. You take your turns talking about them. Cases are randomly assigned. And it's a great process because it's not, you don't have to decide those cases yourself. You have the opportunity to talk with 8 other very intelligent, intellectual lawyers who've become judges and justices. And then for me, I had an incredible staff that every year, we had a great staff lawyer, Chuck Lord, extremely brilliant lawyer. And then the lawyers that we hire basically for about a year to help us go through the petitions and work on drafts. So I've had talent to help me along the way.
Now, when you sit around, so there's persuasion happening there, or people come in with they've already made up their mind. What is that like?
I think there's some, I don't know, I guess persuasion. If there's something, for example, that I'm very interested in, and maybe some other members of the court are not, then I have to persuade others that this is a significant issue that needs to be decided, and here's why. But you're not an advocate for one side or the other. We're advocates for the law and how the law should be shaped. And that's the part of the advocacy that's important. And sometimes your colleagues agree with you, and other times they're not for various reasons. It may not be the right time. The briefing may be okay, but it may take some extra time to really focus in on what the significant issue is. So there is some persuasion, but it's only to make sure that the law is corrected if we think it needs to be corrected, or an issue is resolved if there's a conflict.
Yeah. And so, looking back at the body of work that you've put in there, are there any cases that stand out that maybe provide some insight for, people that own businesses or run businesses that they need to think about as to how it impacts, how the law potentially could impact them?
Yeah, there are quite a few cases that have come out or that came out during that period of time involving businesses, involving how you read insurance contracts, the whole gamut jurisdiction. But for me, 2 of the most significant cases that I had the privilege of participating in was the TXI versus Hughes case. In fact, I've told my children, I think that's why the good Lord put me on that court was for that case, which is just amazing how things work out. But that case involves a horrible accident that happened in East Texas. And It's fatality. But the lawyer, during the course of the trial lawyer, during the course of his argument, mentioned consistently that the accident was caused by an illegal alien. Now, we see that term quite a bit in the news now, but in the courts, you try to decide, we should decide cases based on how the facts of the case, the causation of the case, not whether somebody is brown, black, white, or what have you. And so that's the issue that percolated up to the Supreme Court. Now, before we could get to that issue, the court had to decide whether or not the expert that was admitted to testify in that case was qualified. And Supreme Court decided that it was. And so it took us to the next issue. And the next issue is whether or not that term or any other term could be used in deciding a case. And the Supreme Court decided that the term was used so much that it was prejudicial and that the jury was not able to focus on the actual facts of the case. So I had the privilege of writing that for the court. It's interesting because if you read that case, we're able to find I believe it was an 1881 or 1891 case that came out of that same jurisdiction. But it was talking about how a Jewish man caused an incident and how the jury should not allow somebody from that religion to be involved in the case. And it was just really horrible. But back then, over 100 years, the Texas Supreme Court said that was wrong then, and it certainly is wrong now. In that case, I was able to find by just doing some basic research, and ironically, that there was a law review article that was written by a good friend of mine named Benny Augusto, who cited that case in a writing that he was doing. So I said, oh, this is right on point. Just change Jew to illegal alien or what have you, and it fits. And so now you can't talk about somebody's status because it's not really relevant to what happened in the facts of the case. And then another case I happened to be involved in actually was a dissent. It was the Carroll Severance case. So Severance versus the state of Texas. And it happens to deal with the Open Beach Act. Being from Galveston, it's like, well, I know a little bit about open beaches. We, the public, have access to open beaches. We don't have private beaches in Texas. And probably talking too much about all of this, the history of it. But you flash back to when I was a kid, I had the opportunity to meet the person who's considered the father of the Texas Beach Act, which is former Senator Babe Swartz. So I met him when I was maybe 10, 11, or 12, because my mother, who at the time was a X-ray technician, knew Senator Swartz, and she introduced me to him. And fast forward, I'm in the Supreme Court, and this issue percolates to this court, and I get to write on it. But I wrote a dissent, essentially, saying that the beaches remain open, they should always be open, and that this piece of property that happened to be on public beach after a storm had to be removed, and the state has to remove it. Well, that case was picked up certainly in Texas newspapers, but throughout the country, and I'm proud of that dissent. And that issue was essentially resolved, but we still have open beaches, so no private beaches in Texas. We could walk along the beach, which for me as a kid, growing up in Hitchcock, I can't imagine not being able to go to some part of the beach. Well, that's private. You can't go there. So where are we going? Because we certainly don't have the wherewithal to have a big home on the beach. And so for me, that case was important.
Yeah, oh, that's great. So I was talking to you earlier, and I said, looking back at all the work you've done, what gets you excited? What makes, what energizes you? And you said, I like winning.
Oh, yeah.
So now that you're back on this side of the bench and you're representing clients, and I think you had mentioned, given your vast experience, you do everything from commercial litigation to mediation. You're sought after for that work as well, and a whole bunch of other things. I'm always fascinated with the phases of trial, and for our listeners who are owners of businesses, we always tell them, hey, relax. Most cases don't end up in trial, but some do. But I'd like to kind of hear from you, from your perspective, the phases of trial. So when there's a complaint, all the way to trial and maybe even appeal and maybe even going to the Supreme Court, walk us through the different phases from initial complaint, mediation, maybe arbitration to trial.
Sure. Generally, I just pick a business. Yeah, as I went to business with a good friend of mine, generally things start out great, right? Because everybody has an idea, somebody has an idea, and somebody has the financing to do it. And they start out great, things go well. In my experience, it seems like things go well until you start making too much money. And people say, well, wait a minute, I put in all this money and you only put in sweat equity and you didn't do this, you didn't do that. And then the relationships, unfortunately, start to fall apart. And so sometimes you have an arbitration clause, which means that you have to go to arbitration. You don't get to exercise the courts. And so you go to a private judge, as it were, or an individual, or maybe sometimes three individuals to try to resolve the dispute for you. But if you don't have an arbitration clause, then the next step is to file a lawsuit. And file a lawsuit, it randomly ends up, let's say, in Harris County in one of the civil district courts that we have, or it could be a county court at law, depending on the amount and controversy. But if it's a bigger case, two big businesses are going to sue each other and it goes to court, and those experiences aren't pleasant generally for anybody, because your private information becomes public. I need to see your finance records. I need to see how you spent money on this part of the aspect of the business. And so you have all those public disclosures, and then you have these allegations that are now in a public record. And then during the course of discovery, people have to be deposed. And so you'll depose the owners, depose employees, and then everything good and bad about the business operation comes out. And then at some point, if you can't get your case resolved, then it goes to a jury where 12 people in the community that you don't know are going to decide your fate. So when I do mediations, I just did one a couple of days ago, I remind the parties of that. This is your opportunity to settle the case. You have complete control of everything right now, but you have to decide. If you can't resolve it, then you go to trial. You may get more money, you may get less money, or you may get no money. Because one thing I've learned about being a trial lawyer and being a trial judge is that juries they work very hard to try to get it right, but they're not always predictable, no matter how good you think your case is. So you have to go to that process. And if you win, then the other side may appeal. And then you got the entire appellate process. And then that's just more delay in getting your business issue resolved. So it can be quite taxing, and it can be quite expensive. To hire a great lawyer like Jack here, I mean, it's going to cost you some money because, he has a service. He's an expert in his area of law, and that's worth something. And if you want to be represented well in court by a good lawyer, then, it costs money. And so you have to make a business decision at some point. Do you want to take a gamble with the jury, believing you have great facts, or do you want to try to resolve the issue now and cut your losses?
Yeah. And what about the appellate process? Because I think, maybe at some point, every business at some point gets sued is the running joke. So people are familiar with that and they try to settle. But what happens, what insight can you provide, given your background, into, especially with commercial litigation, when it reaches the appeals phase?
Yeah, let's say if you're not the prevailing party and you have an issue or two issues, or maybe even more, as the case may be, that you want to appeal because maybe the judge made an error on admission of evidence. And now you appeal those issues. And the standard review for an appellate issue is that the trial court's decision has to be an abuse of discretion, meaning that it's just so far out of the norm that no other judge would have made that type of decision. So those are hard to prevail on. But certainly there are appellate issues. You go through the appellate process. You have to hire an appellate lawyer. The appellate lawyer will work with the trial lawyer, and they will review this entire record that happened, the transcript, as it were, and all the exhibits, and then try to narrow down the issues to get the Court of Appeals' attention. Some clients think, well, I got 20 issues I want to appeal. Well, that's never going to work. So you got to pick and choose the best issues, because At the appellate court level, they're reviewing everything, not only commercial litigation, they're doing family law, criminal law. I mean, they're extremely busy, and we have great appellate justices, certainly at the 1st and 14th and throughout Texas. So they're extremely busy. You have to get their attention. So focus on what is important. You go through that process, and if you're fortunate enough to get set for oral argument, then your lawyer has to prepare for that. And it's just making a persuasive argument in front of the court. And then at some point, the court will render a decision, and you may win. And it feels great. But then the other side, well, they're going to appeal it to the Texas Supreme Court. And then that takes additional time. But as I said earlier with the Texas Supreme Court, it selects which cases that it wants. You may think you have a great case as a lawyer. The client may think it has a great case, and you appeal to the Texas Supreme Court, and they say, well, it may be great, but we're not going to take that issue up right now. So you have that process. And it takes time. And time, as they say in the business world, is money. And as we used to say at Cooper, cash is king. So,
how often at the appellate level do they ask the lower court to retry the whole case?
Yeah, I don't know what the reversal rate is at the Court of Appeals, but it's not very often.
Okay.
I mean, you have to say, I think most of us who've had the privilege to serve as an appellate justice and as a trial judge, we respect the jury system. This is the system that we have. You try the best you can as a trial judge to make sure all the evidence goes in correctly, and then you let the jury decide. And once the jury decides, it goes up to the Court of Appeals if the losing party doesn't like what's happened. So there are standards that have to be met before you can reverse a decision that's of a trial court. And so it's not, it doesn't happen often, which is good, I believe. Otherwise, man, we would never have finality in our courts. They'd
Right.
just go on forever. I was talking to one of our law partners yesterday about a arbitration that's been going on in Brazil for almost 20 years.
Wow.
It's just amazing that could even happen, but it does.
What are your thoughts on, and there's a lot of discussion about arbitration versus the courts, what's best for businesses? I know the arbitration companies always tout that they're best for resolving commercial disputes. What have been your experiences with both venues, and what do you think are the pros and cons of each for resolving a commercial dispute?
Well, I like arbitration and I like mediation. It's a good process to try to get your issues resolved, maybe a little quicker. The idea initially, as I recall, was to have this alternative mechanism to keep the cost down. But arbitration is expensive. And it, in my view, can be as expensive as a long trial. The benefits of an arbitration and a mediation is that you keep your business private. It's amongst the parties. Certainly in a mediation, everything that happens in a mediation is confidential. And arbitration, well, same thing. The public will never see the petition, the response to petitions, the discovery. It all goes in front of neutrals, as we say, either one arbitrator or a panel of three to decide. And it may move along a little quicker. And the benefits of going to a jury trial is, well, you have the appellate process. So if you lose, you can appeal. And you can appeal all the way to the Texas Supreme Court. And if it's an issue involving, I would say, diversity, where you have corporation from one state and corporation from a different state, then you go to the federal system. So you have the appellate process. In arbitration, once an arbitration decides, it's final, and that's it. There's no appellate process unless there's something extremely out of line. For example, if there's a conflict that the arbitrator knew or should have known about involving one of the parties, that has to be disclosed. And if for some reason it wasn't disclosed, well, then you might get a redo. But otherwise, it's final. So you have to be willing to go through the process, understanding that once the arbitrator decides, it's over. And you still have all the attorney's fees to play for.
Yeah, I want to ask you a question about mediation.
Sure.
one of the feedback I get from folks is, well, we really don't want to go to mediation because they're ultimately, doesn't matter what the case is, they're going to try to split that baby in half. They're going to find a way to hurt both sides to the point where they come to an agreement. Is that true?
I don't think it's true. I think I've heard that, and I still hear that. I think a good mediator, and I like to think that I am, people from both plaintiffs and defendants side, they come to me to try to get their issues resolved. Our job is to listen, and listen carefully, and then try to decide wisely, and to point out everybody thinks they have a great case. I didn't do anything wrong. My business partner did all of that, until you start peeling back the onion and you start looking at the law and you try to explain that as a mediator to the other side. Generally, the lawyers know these issues, but the clients don't. As hard as the lawyer tries to convey to their clients that the weaks and strengths of their case, it's good to hear from a neutral. Mm-hmm. Here's why I think you're going to lose. And I had that issue just 2 days ago, and the lawyers are great, both sides, and usually that's the case. The lawyers are very good, and so you have a client that they're maybe having problems with or doesn't understand why they could lose, and so that's part of the job. And then you find what's common ground. Okay, we agree to this fact, we agree to this fact, so you get agreements. Okay, so what don't you agree on? Well, the law is this. I said, well, for me, I still practice down there, so I got an idea what the law is. And then I still work on appeals, so I understand, I read those appeals every day. Today, Fridays is when the Texas Supreme Court issues its opinions. Today there was two cases came out, one about arbitration and one about a slip and fall incident. And so I stay up to date on all the cases that come out. And to be able to convey that to the parties that come in is very helpful. And some say, well, the best resolution is when both sides are angry. That sometimes is like that, but I try to find it, okay, figure out what you need. As Mick Jagger says, you can't always get what you want, but sometimes you can get what you need. So figure out what you really need, and that you get to decide today how you want to handle the case. And the mediators, in my view, is only good as the party's willingness to try to resolve their issue. Mm. If you go in, well, I'm not taking a penny less than $1. I don't care what they offer. I've got to have that $1. Well, what about 99 cents? Nope, I've got to have the $1. Well, you got to be able to give and take. And generally, they get resolved. I mean, I'm able to get cases resolved.
Well, I'm sure it helps the fact that you could tell them not just a litigation process, but the appeals process, and ultimately all the way to the Supreme Court. So I think your opinion might be worth a little bit more than the average attorney's opinion. I want to ask you about.
Well,
sorry, go ahead.
One more on that. It's an interesting point you make, because I run into this too, where you're trying to, as a lawyer, give advice to your client, fair advice about their situation. And in that process, you start telling them things that they don't want to hear. And that's a lot of our job as their lawyers. We're looking out for them, and they need to hear stuff that maybe they don't want to hear. And then the client might start to think, wow, this person's not advocating for me. They don't want to fight for me. And I've learned over the years, part of that conversation is mentioning, by the way, this is my honest and fair advice to you. When we go in front of the other side, I sound completely different, Yeah. But they need to hear what the potential outcome could be. But it's true when people are fighting on principle, or they're very emotionally wrapped up in their case, it's really easy to just be like, I don't want to hear that. I'm only going to hear this. And so that mediation process and having a neutral person can at least help, get that message across.
Yeah.
Not every case is clear cut, and the vast majority aren't.
Yeah. So when we're talking about neutrals, arbitrators, I've seen this where each side gets a bank of arbitrators to choose from, and they narrow it down. So if I'm a party to this lawsuit or this arbitration, how should I go about picking which one of what am I looking for in these arbitrators? Or am I simply relying on my attorney to say this person's good, that person's not so good? Or is there anything I could do on my end to kind of scope out to see which might favor my case more than the other?
Yeah, absolutely. I always believe that a client's input is significant, and you want the client to be part of the process. So here's our panel. You, whatever your experience is, let's just pick an expert in communications, and you're very familiar with First Amendment issues and the law as it pertains to what you can say and what you can't say. Well, I want you to look at this panel. Here's somebody on this panel is an expert in construction. Here's somebody who's an expert in real estate. Well, those probably not going to fit, right? So I wouldn't direct you to that. But here's three experts that know communications. They've written on this topic. I want you to read their articles and let me know what you think. And then I'd get that input, and then we'd collectively make a decision. And if I personally know some of the people that are on the panel to choose from, and I think they're good, and I would say that generally the arbitrators that, for example, participate in arbitrations consistently, they have great experience and vast knowledge. And so direct you to look at these, and then we'd make a decision collectively. But a client's input is always important.
Yeah. You mentioned earlier about, one of the perils of going through the court system is that everything becomes public versus arbitration is private. Do you have any insight or any advice on a company who may be fighting a public battle in the public courts, how they can maintain their integrity and their reputation as things come out that maybe doesn't paint them in the most favorable way?
Yes, have a good public relations department. Seriously, to really make sure that their side of the story is told, because the media has a job to do, and they've got to get sound bites. They've got to take a long transcript, narrow it down, and get it out there and air it. And you don't want that to be the narrative sometimes. So you have to control the narrative, and to do that, you have a good public relations firm, whether it's internally or externally, but somebody that understands your story and maybe the case and can talk about it to the extent that there's not a gag order, and you can talk about the facts of the case. Because as we know, there are two sides to every story, right? I got my side, Jack has his side, and somewhere in between, the truth will come out. Even though we believe everything I say is the truth, everything he says is the truth, the jury has to decide where's the credibility. And sometimes you'll get a bad situation that may be not told correctly. And so you need to be able to respond to it. And I think it's always good to respond, because when you say, well, there's no comment, then what does that mean? Why aren't they talking about it? But some companies have taken a position where we're not going to talk about it because it's in litigation, and we'll talk about it after the litigation. So it just depends on how the board or how the corporation decides to handle those. But I think it's always good to have a PR department.
Oh, well, with that, Justice Medina, thank you for your time and all your insight. Appreciate you coming on.
I'm honored to be here. Thank you for having me. I thank the good Lord every day I get to be a lawyer, and it's just a great journey. So thank you.
Awesome.
Information contained in this podcast and accompanying video have been derived from sources believed to be reliable. This content is not guaranteed as to its accuracy and does not purport to be a complete analysis of the topics discussed. Analysis is based on assumptions that may not come to pass. None of the content should be construed as legal or investment advice. You should consult with a qualified professional before implementing any strategies discussed. All expressions of opinion reflect the judgment of the speakers on the date the video was recorded and are subject to change.